Well, thank you, Mr. Speaker, and I rise again today once again to speak to a bill in front of us that actually found its way here through the Senate, which is a completely inappropriate way to bring forward legislation. It should have come here first. It should be a government bill in front of us as such, but they chose that pathway. That pathway is one where they can move things through in a fashion and build their case using their witnesses in their Senate, which they're controlling, to take away the real responsibility debate that occurs in this place. And so this bill is once again dealing with Northerners' rights, First Nations rights, under First Nations rights that are constitutionally protected. Actually, Northerners' rights as well, Mr. Speaker, that have constitutional issues attached to them. And I'll go into this in a bit as I go forward. This bill, S-6, which amends the Yukon Environmental and Socio-Economic Assessment Act, known as YESAA, and the Nunavut Waters and Nunavut Surface Rights Tribunals Act. It's mostly, and we'll be dealing mostly with this bill over the changes to the Yukon Act. The changes to Nunavut Act are very much less profound and simply not controversial to the degree that these changes to the Yukon Act are. There's a high level of opposition to these changes. Mr. Speaker, in September, I was in Whitehorse and conducted a public hearing there on these bills with the assistance of the Yukon NDP through their offices. And standing room only in that meeting room, people wanted to understand what the bills were. We're concerned about the impacts of the bill. Yukoners are sophisticated in their knowledge and understanding of legislative changes. They've been through it to a greater extent than perhaps the other territories. They are a territory which has achieved the highest level of devolution prior to this bill of any of the territories. They are on track with understanding what their rights are and what they see for their future. But there are, of course, the Conservative MP, the Conservative Senator, and the right-wing Yukon Party government who are working together and not listening to the people, not conducting public hearings, not allowing the people of the Yukon a say on this bill. They're doing their stakeholder consultation. They're doing some obligations that they have to First Nations in terms of consultations. But where's the public hearings? Where's the engagement of the public at large? No, they won't do that because they know very well that when they do that, that the real opposition to this bill will coalesce with the First Nations and say no to the bill, no to the changes. Why? Why would people in the Yukon who are concerned about their livelihood and their future be concerned about these changes which the minister has presented as simply ways to increase the economic activity in the Yukon and make things work a little better? There's basically four changes that really upset Yukoners. One of them is providing the Minister of Aboriginal Affairs and Northern Development with the authority to provide binding policy direction to the Yukon Environmental Socio-Economic Assessment Board. This is something that was brought in the NWT, and we had real concerns with it there. In the Yukon, where they've been dealing with a system where they don't have that in place for 10 years, they, of course, are looking at anything like this as an abrogation of their rights and their hard-fought authority over the lands and resources there. Introducing legislative time limits for assessments. That is another issue. I'll bring it up a little bit later. Allowing the Minister of Aboriginal Affairs and Northern Development to delegate any of it or all of their responsibilities to the Yukon government. That's a concern that First Nations really see on the table because, and Yukoners do as well, because what they see there is that we've worked out, in the Yukon, they've worked out an arrangement. They've worked out an arrangement between First Nations and public government. This is very critical to the future of the Yukon territory. I don't think anybody would deny that. That relationship is one that the rest of the provinces are having more and more trouble with every day. With the failure to deal with nation to nation at the provincial level is causing all kinds of grief to all kinds of projects right across this country. So there is concern about how this delegation takes place. Then there's the question of creating broad exemptions from YESAA for renewals and amendments of permits and authorizations. People look at that and say, what's going on there? How can we make sure that that's correct? Additionally, these amendments favor the Yukon government over the Yukon First Nations, the other partner in the YESAA process. The Council of Yukon First Nations has threatened legal action should this bill become law. YESAA was established in 2003 in the fulfillment of an obligation in the Yukon Umbrella Final Agreement, which has settled many First Nations land claims in that territory. In October 2007, the 5-year review of YESAA was initiated and was completed in 2012. The findings of this review were never made public. And now I want to just speak about a little. Unlike the provinces, the legislative powers of the territories are determined through federal statute rather than through the Constitution. So what we in the Northwest Territories, Yukon and Nunavut have is what this Parliament gives us. Section 3 of the Charter of Rights, which is part of the Constitution, guarantees that every citizen in Canada has the right to vote in an election of members of the House of Commons or of a legislative assembly and be qualified for membership therein. The remainder of the Constitution describes the territories as being lesser partners in Canada than the provinces. We have a problem in the 3 territories. We have a problem that we will remain without the authority of this body, House of Commons, giving us our full due under Confederation. We will not have those powers under the Constitution. Because of the reliance of the federal government to devolve the legislative powers and authorities the province take for granted, it is really unfortunate and duplicitous that the Conservatives are taking away powers through these amendments to the Act 11 years after they were granted. I know you might find this amusing that there's noises in the House, but that's something that we all have to live with. The rumbling of discontent in this country towards this Conservative government far exceeds any noise that I've heard in the House here. Yukoners are also angry about the lack of public involvement as this act was developed. As I said, I held a public meeting in September, full house. There was another public meeting held later on in the fall in the Kwalin Dunn Centre where there was standing room only. A few hundred people showed up to it. Now, why would people come out to a very dry discussion of environmental assessment? Because they care. They understand and they care about how their laws are being developed. If we went into the province of Alberta and said, we're going to change your laws about environmental assessment, this is the way it's going to go now, don't you think that the people in Alberta would come out and protest? If you did that in Quebec, what would happen? So why are we treated in this cavalier fashion, where a federal government can come into a territory, do hearings that are with stakeholders only, take the opinion of people that they consider important, and not have any public meetings talking to the people of the territory about what's going on in their own territory? When the original YESAA was developed, the Department released drafts of the legislation in 1998 and 2001 for public review. It also undertook 2 separate tours of Yukon to meet with Yukon First Nations and other residents to review and discuss these drafts. A little different pattern here emerges. Back then, one of the discussion tours lasted for 90 days and went to every community throughout the Yukon. Every First Nations community not only had an opportunity to send in written submissions on draft 1, but each community had an opportunity to have an open public hearing in its community. The way this bill is developed has been so different. Listening to the Conservatives, you would think that this has been a multi-year program, incredible input. The reality is much different. The parties discussed the YESAA process for many hours between 2008 and 2011 as part of the YESAA 5-year review. It was a review required under the umbrella final agreement and not a discussion on a new draft bill. The amendments to YESAA under Bill S-6 that are of concern were never discussed and were never raised by the Conservatives during the 5-year review. These new amendments were introduced with little opportunity to ensure adequate consultation and accommodation. On February 26, 2014, as I said earlier to the Minister, Canada arrived at a meeting with Yukon First Nations and provided paper copies to those in attendance and wouldn't even give electronic copies to those that had to be in attendance by telephone, changing the First Nations relationship to the Crown, changing the First Nations relationship to the Yukon Territorial Government, and we have a meeting where they can't even be there in person. They can't even have copies of the amendments. What's going on there? They had less than 2 months to respond to these changes. This was hardly adequate. Mr. Speaker, consultation means providing the necessary information to the parties. The Conservatives didn't do that step. The Conservatives failed to meet the test of their treaty and common law duty to consult and accommodate. So inadequate consultation with First Nations is required by law. Democracy also requires the participation of the public. And on that score, the Conservatives and their elected representatives did very little, if perhaps even nothing. When I conducted a public hearing there, which as a critic, I knew I was going to be responsible to speak for Yukoners here in the House, conducted a public hearing, met with many of the public afterwards, met with the Grand Council, Chief of the Grand Council. What did we hear? What did I hear? They questioned the constitutionality of the unilateral changes that are being proposed under Bill S-6 that were not discussed during the 5-year review or during the McCrank report. So we've had plenty of, the government's had plenty of opportunities to discuss changes like this, but didn't take those opportunities. They say that the 16th month timeline is out of touch with the reality on the ground, particularly further north where, depending on the timing of the review, the project may have only one summer to conduct any necessary environmental work. So when it comes to the timelines, Yukoners who live there and understand the place say, look, there are problems with a 16-month timeline. That may not give us adequate time to provide the information to the board so that the project can be assessed properly. Another point, Yukoners fear that the First Nations do not have the financial and person resources to adequately assess proposals, and a timeline like this would artificially strain the few resources they have. Well, this is a common problem across the North when it comes to environmental assessment. Companies have adequate resources generally. They don't go into the process unless they do. Many times they're large multinational corporations that can bring more to bear on the subject than a First Nations community that may be the most affected by it. Yukoners see these amendments as an attack on Yukoners' democratic rights and the constitutional rights of First Nations. And by ignoring First Nations rights, this bill will create uncertainty in the mining sector, as First Nations will now resort to the courts to protect their interests. So we had a system in place, Mr. Speaker, that was working. There were some changes required. Those changes were discussed. There were 70 amendments to the Act proposed. Many of them could have been done in-house. The people agreed to them according to the reports that we've heard, although those reports are not made fully public. Instead, the Conservatives brought in these other measures which have the ability to upset the operation of the Yukon in the years to come. Just as in the Northwest Territories, they changed the environmental assessment legislation with devolution, we have 2 First Nations now taking to court over that. Where's the certainty in the process? Where's the certainty to mining companies that want to go ahead and do this kind of work when they're not sure that everyone has come on side and they don't know whether they're going to end up in a situation where what they're proposing is in front of the courts? Social license is a word that this government needs to understand. It should be branded on all their documents. Look, you need social license to move ahead these days. You can't simply be the way you've been. That's not working. You can look at all the pipelines, you can look at all the proposed energy projects across this country, and you're seeing social license is causing grief in almost every single case. So we had a system in the Yukon that was working, that didn't really needed some minor tweaking. What we've ended up with is a series of changes that take it far beyond the pale. But, Mr. Speaker, I've heard other voices of the Yukon speaking against this bill. The proposed amendments in front of the Senate today were not discussed in the 5-year process with Canada and the Yukon government. This is Ruth Massey, Grand Chief Counsel of Yukon First Nations testimony before the Senate Energy, Environment and Natural Resources Committee. It is our view that the YESAA has been operating effectively and efficiently since its enactment in 2003. The federal government now wants to unilaterally make additional amendments to YESAA. We did not request these amendments and do not support them. These amendments are not necessary. This is Mary Jane Jim, Councillor Champagne and Asiac First Nations testimony in front of that same committee. 11 years ago, devolution gave the Yukon government province-like powers for land and resource management. This was an important step in Yukon's history and crucial in Yukon's ability to determine our own future, a future grounded in respectful relations among Yukon First Nations and the Yukon government. With these proposed amendments to what is made in the Yukon environmental assessment process, YESAA, it's no longer ours. That's the Yukon NDP leader, Liz Hanson, in the Yukon legislature, October 23, 2014. Here's another quote. A long list of people deserve raspberries for this needlessly shady behavior. At the top of the naughty list are the Yukon Senator and the MP for the Yukon, who are supposed to ensure that the interests of Yukoners are represented in Ottawa. Instead, they've kept the public out of the loop, other than the MP muttering vague generalities about the forthcoming changes without offering any meaningful specifics. Shame on them. Yukon News editorial, environmental assessment reform should be done in the open, June 13, 2014. And the final one, and I know that Conservatives don't like to hear the real people talking. We believe that these changes will have a negative impact on the tourism industry and for Yukoners overall. As YESAA is one of the cornerstones of the Yukon Umbrella Final Agreement, we are concerned with the Council of Yukon First Nations grievance with a lack of consultation regarding these proposed changes. Moreover, there was no opportunity for the Yukon public and the majority of stakeholders to provide their views through a transparent consultation process. This is the Tourism Industry Association of the Yukon in a November 21, 2014 letter to the Yukon MP. Thank you, Mr. Speaker. Mr. Speaker, the members of this House are here to represent the people of their constituencies. The people of the Yukon don't want this bill. They don't see the need for it. They don't understand why this federal government is taking things away from them that were well established in the Yukon that don't need to be changed. Why is this paternalistic attitude being foisted upon the people of the Yukon? Democracy is about serving the will of the people. If the Conservatives really cared what's important for the Yukon, they would listen very carefully to Yukoners. They're in an embryonic stage creating their own society, their own way of life, their own relationships with First Nations. This is what they are doing. If the conservative people want to participate in there, go to the Yukon and join with them there as citizens of the Yukon. The citizens of the Yukon and the First Nations people in the Yukon should have the absolute right to the final say about how their land is being managed. We've listened to the people of the Yukon. We're ready to work to fight this bill.